Austin, G. Austin.
Mr. Atwood?
Thank you. Madam Chief Justice, Associate Justices, my name is Jacob Atwood. I'm here on behalf of Craig Austin, the appellant. I didn't think I would be back so soon after the DiMatteo case 3 years ago, but here we are. Unfortunately, you'll see that the trial court apparently didn't even know about the DiMatteo decision, because no mention is made of it, and the many very, very good suggestions made in it.
But
wasn't it, I'm sorry, just going to...
Well, I think we're going to say the same thing. It was dealt with quite adequately, in my opinion, in the appeals court decision. Was it not?
It was brought up there, indeed.
Well, it was, Judge Duffy discussed it at some length, didn't she?
Some length.
I'm talking about the trial court at first.
Well, I know it.
Maybe Judge Terry had, good day, what do you call it? Advanced. What's the word I'm looking for?
Changes in the law trickle down slowly in the country.
But I thought Judge Terry had anticipated the Supreme Judicial Court with remarkable clairvoyance.
It strikes me, counsel, that what Judge Terry did with respect to looking at the fairness of the agreement at the time of the judgment of divorce may have been flawed, but because he really was looking at factors that I think we made pretty clear in DiMatteo shouldn't be looked at. But with respect to the time of execution, why isn't it appropriate for the court to say this really is, in essence, a waiver of all rights to support in circumstances that make it quite untenable or unfair?
Well, the judge made a finding that Miss Austin was fully aware of her rights when she executed the antenuptial agreement.
Yeah, that's one of the requirements for sure, and I think those are reasonably resolved.
But then he goes on and says, but she couldn't understand what rights she was giving up, notwithstanding assistance of counsel.
Well, let's assume she could understand. I mean, I would assume, and based on the record I've seen, she could understand what rights she was giving up, that she clearly waived them, she was advised by counsel, it wasn't a question of her will being overborne. All of those things are fine, perhaps, but is it fair that she give up any and all rights to future support? In DiMatteo, of course, it was quite different. I mean, support was really fairly amply taken care of, and the only issue was sort of in retrospect. But that clearly is not the case here.
Why was that not clearly the case? I mean, wasn't she I don't mean fairly in the sense, wasn't she reasonably taken care of even under the agreement? I mean, she wasn't left a pauper. She was left a decent standard of living.
She got a lot more than Mrs. DiMatteo did.
Yeah. But don't we have to look at this? I mean, the whole point is we have to look at the validity at the time it was executed.
Correct.
And at that point, why is this fair if she gives up any and all rights to any future support at all?
May I suggest that we go back to basics? General Laws 208-34 talks about alimony. And it says, in addition to or in lieu of a judgment to pay alimony, the court may assign to either husband or wife all or any part of the estate of the other. That's what the agreement did. She brought $35,000 into the marriage, and she leaves, with appreciation somewhat, a multimillionaires.
Well, that's happenstance. I mean, the real estate market could have tanked, and she could have been left with nothing.
Let me ask the question, if I can, slightly differently. The same question. Is it your argument, specifically bearing in mind Justice Cordy's last comment, that it was reasonably foreseeable, based on the agreement made at the time the agreement was entered into, that she was not giving up all of her marital rights?
She's not being stripped of them, as you mentioned. She gave up alimony periodic payments with the opportunity to acquire a very significant estate, which she did.
And it was reasonably foreseeable at the time she entered into it that that would be a significant estate, in your words?
Indeed, I think it was.
Okay.
What significance, if any, do you attach to the fact that it was her lawyer who drafted the agreement?
I think it's rather significant. She rejected his lawyer's draft, and her lawyer authored the final agreement that was signed.
Mr. Atwood, Judge Duffy, as you know, has had a long and distinguished history in this area, and yet she says, in her opinion, that there was nothing in the evidence, and that's really what I'm going to suggest that the wife would be in a position to reasonably support herself in the event of a divorce occurring well into the future. Are you telling me that if I look as carefully at the evidence as I understand that Judge Duffy has, that conclusion of hers is erroneous?
I'm suggesting that how can you say this agreement was unfair and unreasonable on the day it was signed?
Well, because one of the things that we've tried to do is to say when it comes to marital rights, in part what one is looking, why one has a two-step process is because there are some marriages that fail within hours. Mm-hmm. And there are other marriages that fail 35 years later. And so what might have been reasonable at the time, when looked at in hindsight of a couple of days, really doesn't. And what Judge Duffy seems to be focusing on is to say there's no evidence to suggest that the wife will be in a position to reasonably support herself in the event of a divorce occurring well in the future. And that's in part what we did in Di Matteo by looking at what are marital rights as opposed to saying you can start off with pre-existing property rights, assets, inheritance, and you can say, you can sign an antenuptial contract that says, I agree not to make any claim on those. I mean, that's a very bright line, so we are making it very clear that the mere fact that one is entering into a marriage does not, unlike community property states, entitle you to look back at the assets of the spouse. What we've tried to do is to look forward, anticipating that some marriages will be short, some marriages will be long, and that it has to be reasonably clear at the beginning that a divorcing spouse after a fairly lengthy marriage will be in a position to reasonably support him or herself.
Of course, Mrs. Austin was married before and divorced before, and she had a good appreciation of what child support and alimony was all about.
Yes. I'm really focusing on that aspect of Judge Duffy's decision, which seems to me to be critical in this case.
Well, you have to make a judgment, which Judge Terry did the day she signed it, because you don't have to go any further than that, as he didn't, although he didn't have to. The day she signed it, how does one have a crystal ball as to how long this marriage was going to last?
You don't have a crystal ball, but I think that's why we distinguish between rights acquired during the course of the marriage and whether an agreement, and that's typically why we look at things like spousal support. We don't look at the amount, but if there is, for example, an antenuptial agreement that says to, let's say, the non-wealthy spouse about to enter a marriage, I give up all rights to any of the property held and inheritance and trust funds and so on held by the wealthy spouse. But I agree that should this marriage terminate, that I will have, a modest income. I think the courts would probably uphold that, even if at the time of the divorce it turned out that they had been living on a grand lifestyle for 30 years and she was going to be reduced, as Justice Cowan suggested, not to a pauper, but to somebody with an income of $25,000 a year.
Not a public charge.
Yeah, not a public charge. That, it seems to me, is what we're trying to fashion when we talk about, looking at what the marital rights are that you're giving up. And so I'm troubled by this conclusion of Justice Duffy's that there's nothing to suggest that Donna would be in a position to reasonably support herself.
Wouldn't that be taken into account on the second look, as mandated by Osborne and reinforced by Di Matteo, just as in a divorce case, the length of the marriage is one of the Section 34.
Well, it's an interesting question. If it was unreasonable at the time that it was entered into, but very reasonable at the time of the divorce, I mean, that's an interesting question. As part of the agreement, no alimony, but you can have this little, vacant plot of land that turns out to have an oil well on it. I mean, that would be an interesting.
Could be.
But that's not these facts.
But there isn't any oil in Cape Cod, but there's vast appreciation.
Roughly speaking, how much, putting aside this waiver thing, how much did she actually get when the divorce went through in dollars, roughly?
1.9 million.
Was that largely related to the house?
1.2 million was the house.
So she got half of it.
$525,000 in cash. You might say, why should she have to sell her house? Well, he's selling his assets and mortgaging them.
Was that as a consequence of the antenuptial agreement? I should know this, or was this a consequence of Judge Terry's ruling?
It was really a consequence of the antenuptial agreement.
And his interpretation of the antenuptial
Yeah,
agreement.
She got 50% of what was not his separate property.
I think she got 50% of everything.
Because that was acquired during the course of the marriage?
Sure, and things were mixed and he put
But
the
not
house.
his interest in corporate ventures.
I beg your pardon?
Weren't some of his businesses incorporated? Did she get some part of that?
She did when he sold them to pay her, but not.
Yeah, no, I think the answer is no, but there was an issue about how the antenuptial agreement was worded, and if title in fact passed to the spouse in any respect, then that exclusion of sort of
But I think as a practical matter, she got half of everything.
Let us assume that no real property had been acquired during the course of the marriage, no joint bank accounts.
This comes up all the time, where there's a waiver of alimony, and there's no property involved, and a woman has 3 children.
Isn't that what Judge Duffley is saying?
But that's not what happened.
Well, that's the second look.
Well, when that comes up all the time, the judges must not enforce the waiver clause in those circumstances.
It comes up in separation agreements where people try to put through a divorce action where there's a waiver of alimony. Both sides are perfectly willing, and I think in the wisdom of the court, they don't allow it.
They don't allow it.
They don't approve the separation agreement.
Oh, beforehand.
But they were correct.
Yeah. Okay.
Thank you, Mr. Atwood.
Thank you.
Mr. Curhan?
Morning. May it please the Court, Dana Curhan. With me is Brad Benyon.
So she goes away with, do you agree, with like 1.2 million as a result of this?
She goes away with equity in the house, and she gets 3 cash payments of $175,000 over the course of 3 years.
And that's about 1.2 million.
1.9,
1.9.
1.9.
I think it
plus
probably-
other things equals 1.9.
Okay. In any event, I mean, Judge Terry found this agreement to be not fair and reasonable either at the first look or the second look.
How could he have found it not fair and reasonable at the second look in light of what we've said about what the standard and the metrics of review are?
At the
At
second
the
look?
second look.
Well, first
That
of
she
all,
not be left a pauper? That clearly hasn't happened here.
well, what she did was she waived her right to everything except marital assets, joint marital assets, anything that might be acquired during the marriage. Judge Terry found that in the 3 months just prior to and just after the filing of divorce, Craig made essentially $600-something thousand disappear by moving it from joint accounts into business accounts and other accounts, by making an interest-free loan to an employee that he didn't disclose, and by buying a boat that he didn't disclose. I think once he makes a substantial amount of the marital assets disappear, all bets are off at the second look. The second issue at the second look is he made a finding that she could not, she was did not have the vocational skills to support herself. He found that she had no technical training. She was a high school graduate. She had not worked outside the marriage, outside the home during the course of the marriage, and the judge found, and the evidence supports, that she was qualified for entry-level or minimum wage jobs and nothing more, and that her ability to work would be further compromised by the fact that she had custody of her daughter and could not work full-time.
I suppose you could sort of say you move the house off of the equation because they've got to live somewhere,
That's right.
she and the daughter. The 1.9 million doesn't turn up in the appeals court opinion that I could see.
I'm not sure. It is in, the values are in the findings, and I suppose...
Well, I know they're in the findings, but in the recitation of the findings in the appeals court opinion, I didn't see that sum, so
The
it
appeals,
seems to me to be, a little bit of not exactly stating the whole facts.
well, I think the appeals court focused on the first look and did not reach the second look, so I don't think there was any real need to address that in the appeals court's opinion.
Mr. Cohan, if I look at the evidence, is that, I mean, obviously this conclusion is favorable to you, but there was nothing in the evidence to suggest that Donna would be in a position to reasonably support herself in the event of a divorce occurring well into the future?
That's correct.
Well, what about the fact that she had supported herself before she was married?
She supported herself as, I believe, a sales clerk in a retail store.
But she supported herself, and a child, because she had a child before she was, before this marriage.
We don't know what the arrangement. There's nothing in the record about how she supported herself and what her lifestyle was. She may very well have had child support from her former husband. I don't know. That's not in the record. I think the point is that, at the age of 49, at the time the divorce complaint was filed, what were her prospects for supporting herself? And they weren't very much. Now,
But when you look at, well, okay.
Well, I've got a question for you that I've been trying to figure out. Her lawyer drafted this stuff, right?
Yeah, yes.
So if you take the first look, it's drafted by Donna's lawyer. Why shouldn't we assume that that was fair?
I think you have to look at what it actually contained, what the agreement actually contained. And what it contained is a waiver of any right, any claim on his property, and any claim to future support. Now, if we're looking...
Mr.
Can I
Cohen,
just follow
sure,
up on
sure.
that? So if her lawyer did the drafting and you're telling me now, well, look at it to see whether what was agreed to, then I'm just wondering what you would say the rule is for future cases. Would we say then if parties enter into an agreement in which one party drafts the agreement and then later on they say, well, it wasn't fair, how can parties negotiate agreements if one can draft it and then turn around and challenge it later on? That's not fair, is it?
Well, I think we're reading between the lines. I don't think it was her idea to do this prenuptial agreement. I think it was presented to her a couple of days before their wedding.
Yes, but we've dealt with that.
As
Yes.
your brother says.
That one we can't reach, Mr. Cohan. If there's no factual finding of duress, I mean, maybe a duress, sign the antenuptial agreement, or I'm not going to marry you. That's the choice. I mean, it's not duress in the sense that, that she was misled, there was fraud. I mean, we've really tried to distinguish that. We say, get a lawyer, be advised by independent counsel. No, you can't represent both parties. I mean, we've done as much as we can to make sure that people who are presented with antenuptial contracts on the eve of marriage have as much protection as they can.
I understand that.
If we take Justice Ireland's question a little further, wouldn't we, if we rule in your favor, essentially be saying, well, you can't have an antenuptial agreement that unless it provides well for the wife or for both spouses, whatever?
Well, the Osborne case suggests if there's something in the record that suggests, in the Osborne case it was flipped the other way around. The wife was very wealthy, but the husband was in medical school. So we looked at, the likelihood of earning, reasonable support. what I would ask you to do, Mr. Curlhan, is think of, I mean, essentially it seems to me that we are saying giving up if we were to agree with you, giving up marital rights, all marital rights, in exchange for half of the property is on its face unacceptable. That suggests that you have to have some kind of support provision. But let's assume that this marriage had failed at the end of a year. She's 41 years old. She's now 42. Right? And there's a requirement, let's say whatever she was earning as a sales clerk. I mean, you know, it can be very little. It might be $15,000, maybe $20,000 if she's getting a commission. But this is somebody who is now committed, we are saying, almost as a matter of law, to having alimony paid for age 42 and what might be 50 years. That's a lot of income. I think one of the things that council have an opportunity to do, and we've never said you can't do this, is to have provisions of an antenuptial agreement that deal with short-term marriages and longer-term marriages. I mean, here it seems to me that, you know, and that's why I think we gave the two-step process. You look at the first step, and then, you know, even if you've given up a fair amount that seems reasonable, you've now had a 35-year marriage, you've remained at home, you've raised the children, you don't have any computer training, and you've got no means of support. I think that's why we give a second look at it. But it seems to me that here, that to suggest that Donna would be in a position to reasonably support herself in the event of a divorce occurring well into the future, which is Judge Duffley's test, that, I think, is the second look, not the first look, isn't it?
That might be right. I actually, in the appeals court, I did focus on the second look more than the first look. I think the first look is a problem in that there is an assumption that marital assets would accumulate, and I know my brother made that assumption and said, well, of course marital assets would accumulate, but there isn't. I don't think you can make that assumption.
You can't make that assumption if you're looking at it from a short-term marriage, correct? So
that's correct.
So if you get divorced 2 years later, and you say, then it might be looking at it as a second look. I gave up all of my marital rights, perhaps there's a child, perhaps not. I mean, who knows what's happened, for essentially a valueless asset.
I guess if you looked at the first look, maybe there's a scenario where the couple spends everything or the business doesn't go well and there are no marital assets
Correct.
accumulated. Or maybe you have a situation where Craig makes the marital assets disappear.
I take it what you're saying is, fine, look at it at the second look, and let me show you the assets that he dissipated all over the place that were clearly contemplated as part of the antenuptial agreement.
That's right.
And focus on that and take a look at not whether or not she's a pauper, because that's not what she agreed to. She didn't agree that she would become a pauper. She said anything that's reasonably acquired as part of my marital assets, focus on that.
I think this case actually becomes much easier at the second look than at the first look because, again, she waived everything except marital assets, and he dissipated his...
But why is that? I'm just trying to figure out, why is that a second look analysis? Why isn't that simply, okay, the agreement seems fair on the second look, but except for the fact that someone has diluted the assets. That sort of seems to me a separate analysis.
Well, you look
than
at
a second look. The second look is what does it look like now? And it seems to me it's a further question. Well, someone has dissipated the assets. What it really would look like now, if people had acted in good faith, is what the second look should be, isn't it?
I think that's right. And I think what happened was it looked like the 50-50 split. It looks to me like the 50-50 split is the marital assets. And had there been another $600,000 in marital assets, that would have, where I come from, that's real money. I think that would have made a difference. We don't know. The judge actually found that Craig made engaged in a pattern of making sure that marital assets did not accumulate.
I take it, Mr. Curlhan, what one would be arguing is something like the following. She made an agreement. All assets acquired during the course of the marriage. A little hard to know what those assets will be, probably a house, could be a second home, but there might be bank accounts and so on. What she did not, and if you interpret that anti-nuptial agreement to mean on the date of the divorce or whenever reaching the agreement, you're not doing a one-day snapshot. What's in jointly held property? What you're looking at is all of the assets that came into the marriage in that period of time, correct?
That's correct.
And so this really isn't, you're almost suggesting this really isn't a Di Matteo situation. You're looking to say whether, if you interpreted this agreement, whether it would mean money that was put aside, loaned out, and therefore happened not to be in a joint account at the precise moment that the snapshot was taken.
I think that's right. I mean, at the second look, I think the judge was entitled to say, look, this, there's some behavior here that really minimized the accumulation of marital assets, and I think had he complied with this agreement, with his obligations under the agreement, there would have been a more substantial marital estate to be divided, and
I don't view that as the agreement fair, but rather has the agreement been complied with, which is a little bit different. But it strikes me the adding on of the alimony really goes to the lack of fairness in the agreement, or the judge perceived lack of fairness in the agreement, and that's what troubles me more. The fact that the judge sort of said, no, these assets have to come back in because, in essence, the contract wasn't complied with. Well, the adding on of alimony, which the parties explicitly agreed to waive at the time that the agreement was signed, is the thing that's more troubling, I think.
Well, when they agreed to the waiver, I mean, the judge did enforce the agreement as to his separate assets, as to Craig's separate assets.
Yep.
But when they agreed to the waiver, there's actually language allowing the judge to take a second look at this, and saying that, and essentially saying, all bets are off. A judge can look at it sometime down the road and can decide not to enforce the alimony waiver. So I think in the facts of this case.
But under what standard can the judge do that?
Well, when the parties say you can do it, I take it that the parties are incorporating almost by reference what's reasonable, what's fair and reasonable in the circumstances.
That's
I don't
right.
think you're incorporating in all the requirements under the statute. Correct?
It strikes me they're incorporating the law. I mean, they're basically saying the parties acknowledge that the law is that this can be subject to a second look.
That might be, but I think they're making it explicit. So in case the law changes and says you're not entitled to a second look, the parties made it clear that there would be a second look here.
But applying that language, can the judge only do that if the judge concludes that the agreement at the time of the second look results essentially in a substantial giveaway of the wife's marital assets?
I don't think the standards are stated in there. I think the judge essentially can choose to enforce it or not enforce it, and I don't think there are particular guidelines that the judge has to follow.
Stated differently, if one is advising somebody who has no assets about to enter into a marriage where his intended spouse has substantial assets, the lawyer might say, look, you can make an agreement now, but the best way to protect yourself is to tell a probate judge, well experienced, that they can take a look at this. Correct?
I think that's right.
Or you could just advise the person who doesn't have any money to agree to anything, and then later on they can have their lawyer draft it.
I wouldn't want to pay malpractice premiums having given that advice.
Okay. Thank you,
Thank
Mr.
you.
Fairhand.
Thank you.